maybe the best way to start thinking about some of the specifics in the legislation is the fact that this is coming on the heels of GDPR, the European data privacy law that took effect a couple of years ago, I think in 2018. And then last year, I'm not sure how many people are aware that California implemented a pretty strict and sweeping data privacy law, and the Virginia law is certainly in the context of that. And at the same time that we know that Virginia is kind of on the forefront of passing this, a lot of other states have similar laws in front of them. And so are there any things as we talk about kind of things, Chris, you mentioned earlier that maybe stick out to you about the legislation, also for people that maybe are already a little bit familiar with GDPR, who may be familiar with the California law? Are there any points at which you kind of see either things that really stick out specifically about the Virginia one, or ways in which, if somebody's kind of already brings the experience of having prepared for those other ones, kind of differentiating points that they may want to be aware of?
I think it's a good question. I think the good news for Virginia businesses, or for anybody who needs to comply with the new bill, who has a sufficient number of customers in Virginia, is that if you have already started preparing to, or already in compliance with CCPA, you're in a good position to be in compliance with this new law and with whatever regulations come down the pipeline. The California law is, I think, in some ways slightly more restrictive, actually, than Virginia's. One of the key differences there is that a consumer in California has the option to basically request that the person controlling their data is restricted from processing it in certain ways. And there's some allowance for that in the Virginia law as well, but it's smaller in scope. And the two laws do mirror each other in terms of the fundamental consumer rights that they're creating, which is the right to access your data. That is, to request of a controller, hey, do you have anything of mine? Do you have my personal information? And what are you doing with it? And critically, I think, the right to correct that information if it's found to be inaccurate. Probably the biggest difference between California and Virginia law at this point, then, is with enforcement. And that's the good news for Virginia businesses, is that the enforcement mechanism in Virginia is, I think, significantly more business friendly than it is in California. California has a private right of action, so any consumer, any individual consumer, can themselves bring suit against a controller that has mishandled their data. And you can't do that well, there's no private right of action created by the Virginia statute. To the extent you can locate one somewhere else in the common law, it's there, but it's not spelled out in this statute. Enforcement in the statute is through the Attorney General alone. So essentially, the Attorney General's office will be charged with identifying any missteps and prosecuting those, and then issuing penalties of up to $7,500 per violation. So that's the bad news, is when we're talking about per violation and we're talking about consumers in the hundreds of thousands, that can mount pretty quickly. But you shouldn't get there the way this bill is written. There's a safe harbor provision. Gives you a 30-day, I believe it is, right to cure. So before any action is taken against you by the Attorney General, they're going to say, here's what you're doing wrong, stop it. You've got this amount of time in which to stop it. And only then, if you've not stopped it after that period of time, are you going to be subject to those penalties. So it certainly is something that businesses need to pay attention to. And if you get those letters from the Attorney General's office, you need to read them and think about what to do in response to them. But you don't have to worry about an army of aggrieved consumers out there bringing suit against you individually.
And it's probably worth just re-mentioning again that even if this gets signed within the next month, none of these provisions are going to be taking place until January 1, 2023. So they are giving companies almost a 2-year head start to kind of comply with some of these. Randy, from your perspective of someone who's really close to actually the the real data and process of that, when you think of this kind of safe harbor rule, this kind of 30 days to comply, does that seem like it's really something feasible as far as that's correctable, or do you think that's kind of, I guess does that feel like a real provision that's going to be useful to companies that maybe at the transition point may struggle to kind of get it right from the start? Does that feel like a good outlet, and then a place where issues or problems could be correctable before it becomes these kind of six, seven, eight, nine, 10-figure fines that are kind of hypothetically hanging around out there?
It could be, and it's going to depend on how well the organization understands its process by which it procures, processes, and then ultimately discards the private data that it has on consumers. So I think that what is beholden on businesses right now is to, if they haven't already done the work by being subject to other policies like FERPA or HIP or COPA or some of the other regulations that cover privacy, is to really spend the time working through their business processes where they collect, process, and then ultimately discard or even share or subcontract out the processing of private information of citizens, to make sure that they understand exactly what data they're collecting. Are they collecting just the data that they require? Are they being very clear with themselves and the consumers what they're doing with that data? And then ultimately how they choose to discard that data after that processing is concluded. If you understand that process, even if you see where there are opportunities to improve that, if you do get a letter from the Attorney General, you should be able to fairly quickly assess the issue and prescribe a mitigation that satisfies the Attorney General. I would say the real danger would be if you're choosing, or if you just haven't done it yet, and especially if you're a very large organization with some very sophisticated processes and lots of subcontractors doing processing on your behalf. It can take a lot of time, because you have to wait for a lot of people to respond to you, especially if you're sub processing some of these data through, let's say, alternate processors in other countries and things of that regard. It should invoke people to really take the time to understand their process and document that process.